uh, items to be thinking through regarding the succession of your tree farm onto the next generation. And we built our presentation around 4 key questions that you should be thinking about as you begin to develop your estate plan. The first is determining the value and character of your interest in your tree farm. The second is who you would like to have the authority to manage your tree farm if you become incapacitated or upon your death, who you would like to receive benefit from your tree farm upon your death, and then finally, how will estate tax have an impact on your situation? And if it will, what strategies we can utilize to mitigate or eliminate that effect. Now, while these are the 4 considerations that we're going to be diving into tonight, really, I think the driving issue for most of us on this Zoom call is how to be keeping the tree farm within the family in a practical and efficient way. And so in addition to the legal structures we'll be talking about and the tax planning, there are really 2 key elements that are needed to have an efficient estate plan. And that is everyone in the family wanting to do the right thing and everyone wanting to communicate. And before I turn it over to Randy, I will just mention one item that while the purpose of this presentation is to be informative, and we have helpful information, and we have information that we believe to be accurate based to the best of our knowledge, we are not providing any legal advice tonight, and we really encourage you to talk about these items with your attorney after the presentation. And with that, we'll turn over to Randy Grove.
Thanks, Mike. My name is Randy Grove, and I have had the privilege of practicing law, and particularly in the trust and estate and tax world for a number of years here at the Lander Home Law Firm in Vancouver, Washington. And I'd like to add one other practical tip to what Mike was saying, and that is that the planning process for keeping your tree farm in your family is not a one-size-fits-all proposition. There are a number of different tools that can be used. There are lots of different fact situations that need to be identified. And so what we really aim for is understanding what your situation is, as well as understanding where you want to go, what the objectives are, who the players are going to be. And so I would like to go ahead and focus in on the issue of value. And there are several different categories of value, if you can believe it. The first is fair market value of the timber and land, and that is what a willing buyer would pay a willing seller. And that is the value that's relevant when we are thinking of tax considerations and making either a gift, major gift during lifetime, or a transfer to the next generation upon death. Then second is the real property current use. And you're probably most familiar with the second one. And it's just a fraction of, a small fraction of the actual fair market value that you would be expecting if you were selling the property. And the third issue is estate planning distribution value. And on the slide it states if the tree farm is only given to certain beneficiaries. And what I mean by that is if there are certain people that you want to have benefit that have been by your side for the last 10, 20 years or however long, and you want to be giving a special benefit to them. Sometimes what people do for the purpose of distribution within your estate plan might have an artificially low value on the interest in the tree farm when it comes to dividing between family members, and some who have really been on the team and others not so much. We can talk about that more in the Q&A time if that's interesting to you. Then the second issue is the character, and that really has to do with the ownership. And it can be owned as separate property. Certainly if you're single, that's what it is. If you're married, you can still own as separate property, but it takes special effort in order to do that. If married, then community property. Mike is going to be talking about community property in just a minute, but there's a presumption that any assets owned during marriage are presumed to be community property unless you give evidence to contrary intent. And then third is ownership with others other than a spouse, because there may be ownership between siblings or between unrelated parties. And then how do you own it? Do you own it just outright so that your name only is on the deed? Or do you own it in a trust or an entity such as an LLC? So, Mike.
Thanks, Randy. And as Randy mentioned, a key aspect of determining the character of your interest in the tree farm is making a determination as to whether that interest is community property with your spouse or not. Now, Washington is a community property state. We're one of only about 12 states in the country that utilize a community property system. And essentially what community property boils down to is a very simple presumption, and that is all assets acquired during the marriage, with the exception of gifts and inheritances, are presumed to be the community property of the spouses. And what that means is that each spouse owns an undivided 1/2 interest in all of their community property. And there are a couple of key aspects to community property that are important to highlight. The first is the name on the title does not necessarily mean that person is the owner. Even if one spouse is on the title or on the deed for the tree farm property, if that property was acquired during marriage with marital assets, even though one spouse is on the deed, that property is still jointly owned marital community property. Another key aspect is there is what is called a double adjustment in basis on community property upon the death of the first spouse. And what that means is there is an adjustment in basis on the total value of the tree farm. So 100%, not just the deceased spouse's 50% for capital gains purposes. So just using a really simple example, you purchased the tree farm in 1970 for $100,000, and now it's worth $1 million upon the date of death of the first spouse. The new basis for capital gains purposes is that $1 million value, and the surviving spouse could sell the tree farm the day after first spouse passes away and not have any capital gain realized. And now, so we have talked about the first aspect, the first pillar of developing an estate plan for the tree farm with regard to determining the value and the character of your interest. The next really important question to be thinking through is who you would like to have the authority to manage your tree farm upon your incapacity or upon your death. And now there are several different documents that can be integrated into an estate plan to provide both for management and incapacity and death. And the first you may have heard of, that is a power of attorney. And the power of attorney provides significant benefit while you're living. And what it gives the authority to do is whoever you name as your attorney in fact in that document, be it a child, a spouse, or someone else, that named attorney in fact will have the authority to manage the tree farm on your behalf if you become incapacitated. Now, while the power of attorney is a really beneficial tool, it acts a little bit on an island because the power of attorney is only effective while you're incapacitated. That document will have no authority on management or distribution of the tree farm once you pass away. So the power of attorney is a really effective tool, but it's most effective when it's integrated into an estate plan with other estate planning documents. Now, another document that you may have heard of and that is often the anchor, so to speak, of an integrated estate plan, is a revocable living trust. And I'm going to talk just a little bit about the basics of a living trust, and I'm happy to expand on the mechanics of the living trust in the Q&A. But essentially, the living trust is established while you are alive, and you transfer your tree farm into it and other assets. And all assets that are in that living trust will avoid a probate proceeding upon your death. Now, getting back to incapacity, the living trust can be a very, very efficient tool for managing your tree farm if you become incapacitated, because presuming your tree farm is deeded into that trust, whoever you name as your successor trustee can begin managing the tree farm once you become incapacitated. And that same individual can also continue to manage the tree farm upon your death and distribute it pursuant to the terms of the trust. Now, one other key document that is sometimes integrated into an estate plan, and particularly so in the case of tree farms, is a limited liability company agreement. And we're going to talk more about the mechanics of that in a few slides down in the presentation. And so I'll leave that for another slide. And one last item I will just touch on is a guardianship. A guardianship is a court-overseen proceeding if you don't have a power of attorney or a funded living trust. And it's generally not the most efficient approach. And generally doing that proactive planning on the front end can avoid the need for any guardianship to manage the tree farm. Now, a lot of the documents I've touched on for managing the tree farm during incapacity, such as a living trust, will also be effective upon your death. Now, if you have not established and funded a living trust, when you pass away, your assets will be transferred pursuant to the terms of your last will through a court-overseen probate proceeding. And how that will operate is an attorney will go to the court and ask that the executor named in your will be appointed, and then the court will oversee the executor as they administer and distribute the assets pursuant to the terms of your last will.
Now, the third issue that we want to be particularly highlighting is, who do you want to receive the benefit from the tree farm upon your passing? And of course, this is something that's very personal, and there can be changes based off of circumstances over a period of time. And so you need to make sure that the particular documents that are used are kept up to date so far as this issue is concerned. But examples would be spouse, children, there might be other family members, and there might be charity as well. And then various rights and restrictions. Do you just give it to them outright? And particularly if it was one person who is receiving the tree farm, then that would be fairly simple. Then another aspect is that if there is more than one person, the simplest approach for going ahead and providing in your will or living trust is just to say that particular people receive an equal share. But the warning is, what's simple on the front end can get really complex on the back end, because unless those people who receive an equal share are really well aligned with each other, what you'd be creating is a tenants in common status where, let's say, if there are 3 beneficiaries, they all 3 have equal ownership. And under Washington law, tenants in common have to agree unanimously on any major issue. It's not a matter of 2 out of 3, it's 3 out of 3. And so by giving a tenants in common ownership, even though it's simple, you could be unwittingly empowering an outlier to go ahead and have veto power or worse in the situation. So I encourage you to be thinking it through with more of a plan than simply equal shares. Then the next approach is beneficiaries of a trust. And this provides delegation, it provides guardrails, and it also provides focus. So you might think that I think that a trust should be involved every time. No, not necessarily. It's only if it's going to be helpful in order to accomplish your objectives. As far as the delegation, it delegates the authority for the management and the legal decisions to a trustee. And the trustee has the responsibility to follow the written plan and act in the best interests of the beneficiaries. It also means that no beneficiary has the right to just go ahead and say, hey, I want to be cashed out. You don't have that right as a beneficiary. And so it depends upon how long you want the tree farm to stay in the family. But when you want it to stay in the family for 1 or 2 generations or even more, having a trust can be a very important tool, and having it together with an LLC. LLCs and trusts have some overlap, but basically they accomplish different objectives. The LLC, which Mike is going to talk about later, gives authority to the manager, participation by members. And it might be that the members are trusts who would be, the members would really be the trustees of the various trusts or beneficiaries. So no more about that, but we can certainly go ahead and consider your questions in the Q&A if that's an interesting thing to you in terms of delegating authority, focusing what you want to happen, and also providing guardrails. So on the asset transfer alternatives, really what we're showing here is that on the left side, you can utilize a will and include trust provisions in your will. Then next, moving to the right, you could be having a living trust that has a testamentary trust that becomes effective upon death. And then we'll skip over the designated beneficiaries because you really don't hold real estate with designated beneficiary ownership, but you might possibly have joint tenancy with right of survivorship. But the 2 primary documents for transferring assets to the next generation would be, that is upon death, would be will and living trust. And if you wanted to make a transfer during lifetime, then you'd have a declaration of gift. And we can talk more about that if you would like a bit later.
Thank you, Randy. Now, we've come to the last aspect to be thinking about as you develop your estate plan for the tree farm, and that is, what impact will estate tax have on your situation? And if so, what strategies can we be thinking through and possibly utilizing to mitigate or even eliminate the effect that estate tax will have on your estate plan? Now, there are 2 separate estate taxes that could impact your estate when you pass away. The federal government has an estate tax, and Washington State has a separate estate tax. And I will be walking through the federal estate tax with you first, and then Randy will be giving you an overview of Washington's estate tax. Now, with regard to the federal estate tax, I'm going to start with really good news, and that is the federal estate tax has an exemption amount, and that is the amount that can pass free of estate tax. And in 2024, that exemption amount is about $13.6 million. You can see on the slide there, it's $13,610,000 per person. And so that means that married couples, if there is a little proactive action taken upon the death of the first spouse, can actually combine their exemption amounts. And so in 2024, a married couple could possibly have up to $27.2 million. And I will just say that how you obtain the deceased spouse's unused exemption, or DSUE, is a process where you file a federal estate tax return upon the death of the first spouse, and portability of DSUE is the buzzword for that, and I'm happy to discuss that more in the Q&A. Now, the federal estate tax, it adjusts for inflation on an annual basis, which practically means it generally goes up on an annual basis. The IRS has announced that in 2025, the exemption will go up to just shy of $14 million per person. And now, I've been giving you a lot of good news so far, and that is that the federal estate tax right now, the exemption amount, particularly for a married couple, is in the stratosphere. Now, I'm going to give you some not so good news, is that under current law, the exemption amount is set to cut in half on December 31st, 2025, meaning from 2026 forward, we're going to be working with an exemption amount that's about 1/2 what it is now. It's going to be about $7 million beginning in 2026 per person, and that portability of DSUE will still be available, and the annual inflation adjustment will still occur. However, it will cut in half in 2026. Now, there are a few different strategies to be thinking through if federal estate tax is going to have an impact on your situation. And the first is making lifetime gifts, whether that's appropriate to be happening while we still have this inflated exemption amount or after. Using an LLC, transferring your property into an LLC, and then making gifts of units in the LLC to receive what are called valuation discounts on the amount of the gift and use less exemption. I'm not going to go right now too deep into different types of valuation discounts, but if that's something that you think would be beneficial and federal estate tax would have an impact, could have an impact on your situation, I'm certainly happy to be discussing that in more detail. And the last aspect is something called a special use valuation under Section 2032A of the Internal Revenue Code. And that allows for about a $1.4 million reduction in the value of the tree farm for federal estate tax purposes. Now, again, I'm not going to go too much into specifics right now into how you qualify for that special use valuation, but all I will say is that there are several technical requirements, and it's important to be keeping records and making sure you're aware of those requirements while you're living, so that qualifying for that special use valuation is not a question, but a really easy slam dunk when the time comes.
Let's move to the Washington State estate tax analysis. And Washington State has an exemption, state tax exemption of $2,193,000. Now, Oregon has an estate tax exemption of $1 million. And so if you compare it to Oregon, it's more favorable in Washington. But many states, in fact, all the other states in the Western United States, other than Washington and Oregon, do not have any state estate tax. There's only federal. So it depends on who you compare to as to whether you feel pretty good or not as good about that. However, Washington State does have a targeted deduction that if the tree farm meets the 25% test and the 50% test, and it's qualified as a woodland, as a farm, and there's been material participation by the qualified owner, that is the person, the taxpayer, the parent who owns it, during 5 out of the last 8 years prior to death, then all of the value in the tree farm is deducted from the person's estate for Washington State estate tax purposes. And so I'll just make a couple of other comments right now, and we can talk more about this in the Q&A, that you need to document the care that you give, the kinds of things that Molly is expert in. When you document that you do those things for your stand of timber, that is important in helping verify that there is farm use and that you are active in material participation. Material participation really is making the overall decisions as well as having either direct or indirect participation in carrying out those decisions. If you simply lease out land and get a cash check, that's not going to qualify for the deduction we're talking about. But if that was your relationship to the land, you probably wouldn't be on this webinar anyway. So just saying that there are certain aspects that you need to make sure that you meet, and when you do meet it, very big benefit. And there needs to be qualified heirs, basically children or other close family members that receive the real property, but there is not a continuing obligation on the part of the qualified heirs to necessarily be meeting all of these tests. And until they want to go ahead and pass the property, the farmland in tree farm in their estates and qualify for the Washington State farm deduction. So this is something that is particularly important to be thinking of during lifetime, so that your family is queued up for being able to qualify.
And now we have talked a lot throughout several slides about the benefits of having your tree farm in a limited liability company, an LLC. And now while there are several tax benefits to that, I want to talk a little bit about the non-tax benefits of having your tree farm deeded into an LLC. And the first is that it's a little bit intuitive. A limited liability company provides limited liability. And so the LLC will provide a firewall against liability. And so somebody slips and falls on the tree farm, somebody's walking and is hit by a limb, that person can sue the LLC and could receive an award of up to the assets in the LLC, but they couldn't sue you personally. Now, there is one exception to that, and the only exception to that firewall is personal negligence. So if you are personally negligent in any way, that firewall can be pierced. But in general, the LLC provides a firewall against personal liability. The other benefit of having your property in an LLC is it provides a much more efficient and simple approach for lifetime gifting. And I'll just give you an example. If you owned your tree farm outright and you wanted to make gifts to your children, you would need to be recording like serial deeds. If you had 3 kids and you wanted to give them each a percentage-based interest, you would need to record at least 3 deeds. And if 5 years, 10 years down the road, you want to be making a gift of an additional interest, you would need to be recording more deeds. And in addition to that administrative inefficiency, there would also be the aspect of you owning the property as tenants in common, which Randy talked about earlier with your children. Now when your property is in an LLC, there's only one deed. The property is deeded into the LLC, and then to the extent you want to make gifts to your children of an interest in the tree farm, you execute a simple declaration of gift and a transfer of units, and you transfer units in the LLC rather than a deeded interest in the property. And another item that Randy also alluded to in an earlier slide is that having the property in an LLC can really facilitate the efficient management of the property in terms of transferring the property, making major decisions. And the LLC will have what's called an operating agreement. And that operating agreement will define how new members are added to the LLC, how major decisions are made, how distributions are made, how taxes are paid. And also, importantly, I think in this context, that LLC operating agreement can have what are called transfer restrictions that promote keeping the LLC units within the family upon the death of a member of the family. And One final note on the LLC is that if you do have an LLC with multiple members, so let's say you own an LLC along with your children that owns the tree farm, that LLC would need to file its own tax return on a calendar year, April 15th basis, and that would be a partnership tax return, and that's IRS Form 1065.
Thanks, Mike. Let's wrap up the presentation part by just reviewing over the page that says answering the questions. We don't have the answers, but when a client comes in to talk with me, I do my best to try to draw the answers out of the client. So you are the ones who really have the answers. But in order to do that, you need to define the objectives. And in the matter of if the objective is to keep the tree farm in the family, then it's a matter of putting the right tools into the plan in order for that to be practical. And one of those issues is considering the working relationship among the future beneficiaries. I've had situations where people want to go ahead and put their children into a relationship after the parent has died when there is not a good track record of cooperation during lifetime. My observation is that after the death of the main owner, the relationship that the future beneficiaries have while you are living is magnified, both on the positive and the other way. Then there can be, it can be very helpful to be having a service provider team that can also give guidance and support to your beneficiaries. And so having the type of service provider team that you have confidence in can be helping develop this succession plan and also bridge to the next generation. Estimating the asset values and available liquidity for various purposes is extremely important because remember, upon death or upon gift, it's not the property tax value, it's the fair market value of what a willing buyer would pay a willing seller. And then, of course, implementing the plan and necessary strategies, doing it by good planning based off of your timing rather than off of a difficult circumstance. We want to be helpful in taking your questions and responding how we can. And so I'll just turn it over to Molly at this point.
What an excellent, excellent presentation. Thank you both so much. I can't believe how much I learned in such a short period of time. And I really appreciate your talents and be able to translate some pretty complicated stuff into easily digestible material. So to our audience, guys, I've got about 4 questions here. And I do, this is when they start coming in. So if we get to the point we run out of these, we have a pretty intimate group here. I would like to open it up to the audience as well, just so we can have kind of a back and forth. However, before we do that, we do have kind of a couple common themes emerging. The first thing that I would like to touch on is Washington State estate tax planning. There are a couple follow-up questions on that. So specifically about recording the management activities. So from my side of things, one of the services that we provide is walking small forest landowners through creating a forest management plan. And that is a way that basically all of the landowners can kind of get their ducks in a row in terms of what objectives they value. And it's also a tool that can be used and delivered to cost share programs that can be provided through like the DNR and NCRS and entities like that. So Mike and Randy, are you familiar with forest management plans? And if so, can this qualify as a farm activity? Can this qualify as a form of those records you were talking about? Yeah.
The real issue is having credibility with the Washington Department of Revenue when the estate tax return is reviewed.
Okay.
And it depends upon various factors. One of them is whether there has been recent cutting of timber and recent planting. And so if you have that kind of a situation at the time that is relatively recent in proximity to the time of death, then it's easier to go ahead and have a credible activity. But if, let's say, there hasn't been any cutting for a number of years, if you don't have documentation with regard to your forest management plan and the activities that have been conducted in order to show that this is really a tree farm that it has active management to it, then it becomes much more difficult to go ahead and convince the Department of Revenue that you're entitled to the deduction. So keeping those factors into account, I would say definitely best practices to be having the forest management plan. It keeps you on the straight and narrow. It's what you should do anyway. And it can either be really save you if you haven't had recent cutting, or it can just improve your stand of timber, which is what you want to do anyway.
Thank you. That's excellent. Excellent advice. So someone was saying, what if you're waiting for a better market for your alder, for example?
You know, that what I was mentioning, I'll just build on what I was saying before. If you haven't done any cutting and you're always waiting for a better price, then just going ahead and giving that factor to the Department of Revenue of if they don't see a track record of sales, then that factor alone of waiting for a better price is probably not going to be too convincing unless you support that with forest management plan and in demonstration of activity. But this is, but it is a good factor, a legitimate factor in the sense that you're in business. You're not just cutting blindly. This is an executive decision that is a very important one because your crop doesn't come every year, obviously. And the Department of Revenue would understand that as well. But you need to have context and develop the facts in your situation through the means we've already discussed, so that you, as I'll just repeat my same phrase because I think that you would grasp what that is. You need credibility. What will be credible? Ask yourself that question. You'll make a lot of good decisions.
Okay. Someone also, just one more follow-up. Do you know number of hours per year that need documenting? They said we have TMP, but some years don't harvest.
Right. Okay. I would say that it's not so much the hours per year as it is the activities that are needed in order to accomplish your objectives and improve the stand of timber. So if you have a good forest management plan, not so concerned about whether it is X hours or Y hours per week. But if you said what would be ideal, oh, well, 30 hours a week would be ideal, but that's not the situation that is obvious. I mean, essentially, if somebody has a full-time job managing the farm, the tree farm, then you easily qualify. But that isn't usually the case. Also, you can qualify by having family members carry out the material participation issue. And so that you can team up on satisfying these requirements. This isn't simply one person, and particularly when a person gets into advanced years, it's totally unrealistic to be thinking that the elderly person is going to be doing more than just executive decision-making, or even delegating that to other family members. So this is qualification as a team, not simply by the senior family member owner.
Excellent. All right, so we have some, I think a lot of people want to learn more about the trustees, multiple trustees being listed as successors. And then we have a couple, I think, really quick questions that we can rattle off. So I'm going to hit those first, and then maybe we can go into the next, that next group. So for Form 1065, do two spouses qualify as multiple members?
Actually, if it's in the great state of Washington with community property, that is not necessary. And so if it's in Washington community property, then the partnership tax return is not needed. Different answer if it's in Oregon. But anytime other than husband and wife, that there is more than one owner, then there will be multiple owners needing to file a Form 1065.
Okay. Someone wanted more detail on real property current use and what that means. That was from the very beginning of the presentation.
Yes. You know, under the value, and so
In terms of valuation discounts,
well, no. Just the value for real property tax assessment purposes, paying real property tax. That is, if you qualify for a forest or timber use, and you will have filed a timber management plan in order to do that. This is really the basis for payment of property tax, which is based simply on the current use value, and you only pay based off of just a fair fraction of the fair market value of the tree.
Okay, that makes sense. Ooh. Oh, great. She says thank you. Okay, couple more quick ones. Oh, any suggestions on how to find a CPA with timber expertise?
what do you say, Randy?
You know, that is a good one. I would say talk with the best forester, you know.
Hey, there you go.
And or other attorney who also works quite a bit in this area. And so, of course, it just and there are certain centers, areas where there are a lot of people who own timber. And so in our area in Clark County, there are quite a few timber owners and CPAs who have a high level of expertise. And if somebody wants to have a referral, you know, I could do my best to try to find a referral as well for one of my contacts who would know someone else closer, or you can use a CPA from a different county.
Okay, that's good to know. Okay, let's dig in while we still have you guys into, all right. So there's a lot of questions about if there are multiple trustees that are listed as successors. And then really locking in on the unanimous decisions. Like,
Unanimous.
how do you say that?
Unanimous.
Oh,
Yes.
unanimous. So when does that become an issue? And so someone suggested, is that like when someone who is unhappy goes to court? Are the tenants in common policed? I think people just want to hear a little bit more about that. I know it can be a pretty common situation.
Yes, well, very good question, Bolling, and there's a lot to break down there. So let me know if I don't touch on every point in my response. Now, the first item is that whoever is named as the successor trustee, and that's generally one person. Now, there will be multiple beneficiaries, presumably, of the trust who can receive benefit when the trustor passes. But there's generally, not always, there's generally only one trustee who has the authority to be managing the tree farm when the owner becomes incapacitated or passes away. I'll stop there and see if that answered your initial question.
Yes.
It's
Okay.
And it's also important to observe that the most common approach, if there's not much effort that has gone into the estate plan, is to simply give equal shares. Giving equal shares automatically results in, unless there's an LLC, let's just say there is no LLC, then the equal shares, say among 3 children, will be each owning a 1/3 interest in the tree farm. And if they don't agree, then you can't sell, you can't cut. You're really in a situation where it's difficult, very difficult. And yes, there could be a matter of going to court, but that isn't always a very good solution, because all the court can do, all you have a right to, is either a segregation of the property into 3 portions, which could be a disaster. It could be possible, but it could be a disaster as well, or a court-ordered sale of the property. And so the court solutions between tenants in common who don't get along and can't reach a consensus decision or unanimous decision, the court solutions aren't good.
Are there any better approaches that you would recommend? I mean, maybe, so someone says, all right, let me ask this question. Can you create an LLC to own a share of a property? If one person owns 2/3 and an unrelated person owns 1/3, can the 2/3 be made into an LLC? Is a question.
Yes.
Okay.
But then the 2/3 LLC needs to be able to get along with the other 1/3.
Okay.
As well. So there would need to be a management agreement or a tenant in common agreement, because the 2 LLCs might be tenants in common with each other.
So it sounds like it really does circle back to this final slide that you have here, where a lot of this conversation needs to be happening while everyone is still with us and not waiting until the death has occurred.
Right.
Yeah.
You don't want to assume that simply because you've told somebody what your intent is, that you are doing everything necessary in order to have your intent realized.
Really well said. Yeah. Yeah, I like what you said about any dynamics that were ongoing during life can be exaggerated after the deceased. I thought that was pretty poignant, and I can definitely have seen that play out. It's really good advice. We are getting towards the end of our hour here. So I just want to thank you both so much for just speaking so honestly and plainly and clearly about all of these really, really tough issues that I know either have already affected us or are waiting for us, down the line. So, guys, I don't know if you saw your email, but both Mike and Randy generously shared these materials with us already. And so they were distributed as attachments, so you can go back and refer to these slides for your records. They also generously allowed us to record this, so it will be posted on our website as well. And folks, if you do think of any sort of follow-up questions, please do send them to me, and we'll work towards getting those resolved. And yes, okay, Lisa, thank you for piping up. She said, I will say that writing our forestry plan was the best thing we've ever done to get the conversation going with our kids. So I think that really sums it all up very well. Keep an eye out for our coach planning programs that come up. We can help you do that. Again, Mike and Randy, we are so grateful to have you. Thank you both so much for staying late and spending this last hour with us tonight. I think everybody thought it was super helpful. We really appreciate you both.
Our pleasure.
Thank you. It was a
Thanks.
blessing. Thank you.
Thank you
Thanks.
so much. All right. And that concludes it for us tonight. If it, like I said, I'm gonna go ahead and just put my contact information in the chat box, but Mike and Randy, feel free to sign off. We've kept you long enough, while I just tend to any sort of remaining questions that are in the chat.
Thank you.
Thank you.
Have a
Good
good
night.
evening.
Thanks. Thank you all for sticking around. I really appreciate you guys for being here. I hope they said that they wanted to come back and address some of these topics more specifically, because it's so much information to digest. So look forward to that. They're really happy to be involved with the group. And I'm going to put my email address here in case anybody has any follow-up questions that I can send to them, and I'm sure they'd be happy to answer. That's me. Thanks everybody for staying up late. Appreciate you guys. Okay, have a good night. Bye.